Symposium, and what a great turnout for the last panel today at 4:15. I'm extremely excited about this, and people keep still streaming in here. I'm really delighted to be able to moderate this panel. My name is Calo. I work here at the law school at the Center for Internet Society. And thanks so much to Holly and to the other members of the Stanford Technology Law Review for putting this wonderful symposium together. I think it's been really fantastic. And so I just want to quickly introduce our panelists, and I really mean this when I say that it would be hard to get a really better set of people to discuss this particular issue. Just really have wonderful folks here to talk about this today. So I can start just on my left here with Jim Harper, and he's a director at Cato, and is a member of the Department of Homeland Security's Data Privacy and Integrity Advisory Committee. He's the author of many books. He recently came to my defense in an op-ed, which I really appreciate. And we're really delighted to have him here. If you want to check out more of his work, it'd be hard to miss it. But I would start actually with a great back and forth between Jim and Marc, who's another panelist in The Economist recently, which I thought was really fabulous, and go from there. Obviously, Marc is the executive director of Electronic Privacy Information Center in DC and an alumnus of the law school. He has testified numerous times before Congress. Is the author of many books on the subject of privacy. Has taught for many years at Georgetown, privacy and the like. Also, recently found out that he's a tournament chess player, so I've been hitting him up for various recommendations on what to look at there.
Open with the King Kong.
Yes, King Kong. You heard it here. You take nothing else away from this panel. And then finally, Professor Paul Ohm is a professor at the University of Colorado Law School and the author of many great articles. Definitely a person that when I was starting out not so long ago, I just went and read everything that he had written. He's one of those people that you really want to start with as a privacy scholar, former justice, prosecutor, and also responsible for some of the wonderful things that are going on these days at Colorado, among other people at Flatiron, and they're doing some really wonderful work out there, including in privacy. And so, with that, I just want to make sure we can start and get into the substance as quickly as possible, but we're really lucky to have this group here today. And so this is a symposium about internet intermediaries. And in a way, privacy and the issues around privacy don't fit as perfectly into that notion. That is, they're not necessarily intrinsically issues of intermediary liability. And so that said, the role of intermediaries turns out to be extremely important to a number of different policy debates in privacy. And so we're going to start with a sort of most obvious, concrete example of a way in which we think about liability for intermediaries, and then sort of move away from that a little bit over the course of our questions. And so really the first core question I want to ask today, and I'll start with Jim and then sort of move down the line on this question, is what are the circumstances, if any, where an internet service provider can be held liable for something that a user does on a website? Right? So this is a sort of core question of liability, and it's not an easy one because of the fact that websites have so many different players doing so many different things. And so I'd like to start with you, just to set the initial tone here, Jim. I mean, under what circumstances do you think they should be? So, for instance, as one example, kids in Italy uploaded video of a handicapped person, and it stays on there for a little while. Google executives end up getting criminally charged.
Right. Well, thanks, Ryan, and thanks to STLR, which I guess is what we call the law review. And you, Holly, it's great to be here. They'll all say that being here today throughout all the sessions has made me glad that I'm not in law school anymore. So the question of liability, it doesn't fit in the same way as Ryan said with some of the other doctrines we talked about earlier, often the question is of primary liability. And so maybe a little bit of definition setting is helpful in terms of what we're talking about when we talk about privacy. I'll take a quick second. There's sort of 5 or 6 different interests that people are talking about when they use the word privacy that I think are important to understand. One, and probably the primary sense, is control of information about yourself. When you put on clothes in the morning, among other reasons, it's to control information about the appearance of your body. Another, likewise when you go online, if you withhold information from someone, you're controlling that information, protecting your privacy that way. People don't really know how to do that online, and that's one of the biggest problems. Fairness in the use of information, once it's out there, is another quote-unquote privacy issue. The Fair Credit Reporting Act is often referred to as an important privacy law, but it's really, like the name suggests, it's really about making sure that information is used fairly. Is the data accurate enough for the decision being made? Is the algorithm or decision rule appropriate for the circumstances? Seclusion is another. That is, people wanting to be able to access things online without being constantly bombarded with messages, or not wanting to get telephone calls at the dinner hour. Liberty is another. You're all familiar with the privacy cases in the Supreme Court law that deal with the right to abortion and other medical procedures. So we're talking about a lot of different things in privacy, including I think, the control sense. The example you used, Ryan, where a third party, Google, was held liable for hosting a video that someone else had uploaded. Maybe the core issue there is fairness, because the video was, as I recall from the reporting of it, was an ugly video, inappropriate video of a person I think maybe was suffering mental retardation, being abused in some way. That's really unfair. We all, in our guts, feel that's wrong, and so it's fair to say it was a privacy violation. Is it appropriate for Google to police its systems in order to protect against that kind of privacy violation? But we've heard about the balancing that has to go into place for that. I tend to think that Google should not. I have my own experience. I run a website called WashingtonWatch.com. It's a very small compared to a Google. That's an understatement, yes. Even with my 3 visitors per month, I have trolling, and so when I'm doing this stuff in my spare time, I've got to deal with lots of very complex problems. Maybe I know their complexity because I work in this area. Other people are impersonating someone else who's on the site, or they will post something and then contact me claiming that what they've just posted is defaming the alter ego that they've just adopted to contact me with. Really, really diabolical stuff goes on. And I'm just one guy doing a thing in my spare time. So I understand well the costs in the real world that you get when you impose liability on a third party.
Well, let me put it to you this way, right? So you find out, somebody puts something up on your website, you find out because of a news article or somebody calls you, that this is actually really private information that shouldn't be on your site. I mean, and if it were to go to a court of law, it would be determined dispositively that this came out of some kind of ECPA violation or something along those lines. So, whatever. The point of that is, it's definitely a privacy violation. Then you decide not to take it down, for whatever reason. Right?
I'm feeling extrapolous one day.
Yes, one day you're just like, I'm not taking that down. Should there be a legal remedy against you?
No.
And why not,
Well,
right? I mean, this thing is up there and it's bad news.
Let me explain how I think about these problems myself. And I do have an ad hoc policy that personally identifiable information will be taken down at the request of the person whose information it is. That's even hard to administer because I get people claiming one identity that I can't confirm. And they might be trying to take someone else's post off the site or something like that. Contact information, I'll take that down based on request. I've had people post private mobile phone numbers of senators, and then I get a call from the Capitol Police when that happens. But I don't want legal liability to be there. I'm in a good position. Now, I've spent a lot of time working on this. It's a big hassle for me, but I'm in a very good position because I understand the law. People unlike me who don't understand the law should be able to run sites like this. And I think that the general rule against third-party liability allows the very smallest, as well as perhaps the very biggest, the Google, allows the very smallest to experiment and try this stuff out. Now maybe there's, you might be able to come up with the extreme case where obviously anyone should take some information down. But really, the party doing the wrongdoer should be held to account for this kind of thing, not the intermediary who happens to use the internet to provide a service to the public.
Okay, so Marc, then moving to you for a moment. I mean, here Jim has this one website. He's just one guy, and he only has 3 visitors in a month. And here Google has just tens of thousands, millions of different people posting all kinds of different stuff. And yet, because something they didn't take down in sort of the time that a couple people thought that they should, suddenly they're imposed criminal liability. What's the justification for it? I mean, is that right? And how can we justify it?
Well, I will answer your question, Ryan.
Yeah.
But because I'm increasingly becoming one of the old timers in the world of internet policy. Let me just take people back to the time, which I know will be familiar to some of the folks in this room, which was pre-Section 230 of the Communications Decency Act, where we had cases like Covey versus CompuServe and Stratton Oakmont versus Prodigy, which basically tried to answer the question, if you're an online publisher of information, not necessarily your own information, but occasionally, more likely you were running chat sessions and message groups and making it possible for other electronic publishers to make information available online, what could be the extent of your liability for materials that we might agree as a legal matter would create a liability? In other words, if we stipulate that there's defamatory information, as there was in Covey versus CompuServe, are we going to hold CompuServe liable? I think it was called Rumor Monger. I forget, these were 2 sort of competing online newsletters that got into kind of a nasty battle. And one said about the other something that the parties agreed was defamatory. And the question is the provider of that information now going to be held liable for those statements that have been made available through the service? And I think the intuition there, which is what your question is driving us toward, is the sense that if we're going to promote this online world of robust publication, we simply don't want to give the responsibility of the editorial pen to the service that's providing the platform to enable online comment. And the analogy, of course, was made in the early days to the online bookstore, newsstand, or library to convey this sense. You know, distributors have even greater First Amendment protections than newspapers do, because as a general matter, we don't have them looking into the contents of the books and publications to make available to others, which is a good thing. Now, I won't replay the whole 230 argument, because I know there's a very good conference taking place at Santa Clara tomorrow, and some people are participating in that. It's an important discussion. But I'm prepared to concede at the outset the very important public interest in avoiding liability so as to enable this kind of free flow of information. That certainly was the underpinnings of ACLU versus Reno. Now, I think we need to talk with a little bit more specificity about the Google video case in Italy. Because when you begin to drill down into the facts, at least in my opinion, and you and I have disagreed about this, but in my opinion, it doesn't look like Covey versus CompuServe. It doesn't look like the arm's length, millions of messages going by. How can we be possibly responsible for seeing what everyone is saying and therefore taking on the responsibility for editing? What was happening in that case was that Google was trying to launch an online video service, and this was pre-YouTube. It was actually called Google Video. And as they do with all their products, based on interest and linkings and viewings, they were creating a ranking structure in which the most popular videos became most accessible to others. And they were on the website simultaneously generating commercial revenue through advertising. So they're trying to draw people to the website. They're making determinations about which videos to promote. And frankly, in my mind, whether that's done by an individual or an automated process really doesn't matter very much when you start to think about agency, because the automated process is still in control of the company that makes those rankings available. And the top video for a 2-month period was of high school students beating up a child with Down syndrome, because people looked at that and they thought, boy, wasn't that crazy, wasn't that wild? Have you seen that video on this new Google site in Italy? And Google was told over a 2-month period by numerous organizations, including the National Association that defends the interests of children with Down syndrome, this is really offensive and you really should take it down. And Google resisted. And it was only at the point that the police threatened a prosecution, that was the triggering event, at the point that the police threatened the prosecution, that then they decided to take the video down. Now the prosecution proceeded because of the widespread public availability of that video over a 2-month period. Now I think this is a hard case. I mean, I think it's a hard case because the understandable defense to Google's action would be, well, if we open this door, in other words, if we say that they do in fact have a responsibility to take down such a video, where do we stop, right? And I think that's a very real concern, and I don't think it's an easy question to answer. But I don't think that that concern leaves us with a very satisfying answer either. Because you see, when we now begin to think about the consequence of this particular business practice, the very real harm that I believe it imposed, somehow it doesn't sit well with us, right? So I just wanted to give a somewhat long answer so as to make clear, obviously there's a strong policy interest in not putting online publishers in a position of having to review all message traffic, because that would discourage online activity, but you do get to these hard cases, and I think they will cause you to pause.
Yeah. So I mean, obviously, as you said, I understand the facts a little differently, but that's not the point. The point is, given the facts as you stated them, it still is a hard case, and sort of where do we come down. So I want to turn to Paul for a moment to weigh in. Where is that line? Do you have any thoughts on where that line is? I mean, if we can all agree that we want to protect these platforms, because after all, who would create a communications platform every time somebody was a bad actor, including with respect to privacy, take it down? On the other hand, you have these situations where things are up, everyone knows they're terrible, and it's easy to do.
And so I wanted to also start by thanking Stellar, or since I'm a board game player, Settler, for having me today. It's been a really illuminating day, and I think maybe one way to get at that question and also tie us into what's happened earlier today is to talk about how privacy law is different than copyright and trademark. And since I consider myself not an expert in copyright, trademark, or Section 230, this is the perfect opportunity for me to opine at some length. I mean, so let's talk about some differences. First of all, with copyright and trademark, you have these source of rights being these kind of comprehensive statutory schemes. With privacy, as Jim, I think, was right to point out, you've got this weird constellation of common law torts and some very narrow statutes, and this is just the American situation, it's very different abroad. You've got the importance of the rights, so here's where, I figure the later in the day it is, the more controversial things I'll try and say, so here's a controversial thing. To quote my good friend Jennifer Granick, copyright debates are about, oh my God, someone copied my stuff. But in privacy, you often talk about tangible, very, very, very intimate harm of the kind that's very, very easy to conjure and bring to mind. A big part of this has to be where are the moneyed interests. So in copyright, you've got all these interest politics at play. In privacy, there isn't really the, invading privacy lobby, Google notwithstanding, especially when you're talking about, cases like this where it's person against person sort of harm. But then, of course, the most important one is the fuzziness of the right. So when has someone's privacy been breached? I mean, that's a topic we can talk about until the cows come home, and we still won't have a lot of agreement in the room.
Jim says loss of control over information.
Loss of control over information, but that is a threshold that I think is at a certain level of generality easy to understand, but when you apply it to particular facts, I think that covers either everything or nothing, depending on what you really mean when you say that. And so that's the problem, I think, with trying to impose too much intermediary liability on something like privacy, because now you're asking someone to really answer an impossible question every time that there's a privacy allegation made. I mean, say what you will about fair use being hard to apply. I think it would be much harder to figure out a defamation standard or an intrusion and seclusion sort of standard on a case-by-case basis. So, you know, that I think militates strongly against too much intermediary liability. But I do want to say, and I'm not taking part in tomorrow's panel, that I can't let it go without saying that if the only countervailing concern is innovation, then I think there's a much broader conversation to be had about what do you mean by innovation and how much innovation is enough innovation. I think too often in 230 debates, one side will say there's no such thing as too much innovation. The more we can turn up that volume knob, the happier we are. And I don't think that's right, especially when the countervailing thing is privacy. So there, I've said two completely contradictory things in the last minute. I'm pleased with that.
I want to get a chance for you to react in a moment. I just have one quick follow-up question for Paul. So what about a situation though where like we polled the entire room and everybody but two people say that that is definitely a privacy violation, and Jim decides, I don't care, I'm leaving it up. You know, then we don't have your case about how it's difficult because it's hard to figure out how to apply. I mean, we know it's wrong in a sort of privacy.
But that's this room, of course.
Okay.
I mean, I'm fighting your hypothetical a little bit.
Yeah.
Right. This happened in Italy, so there'd be a different room we'd have to poll.
But I mean, so I guess I'm just trying to bait a panelist to say the following. Okay, so I'll just say it. Is privacy one of those places? And I'd like to get your reaction. Is privacy one of those places where it just shows how Section 230, the fact that you don't necessarily have to take something down just because it's been adjudged illegal, it doesn't show that Section 230 is flawed in that way. I mean, in other words, is privacy one of these places that really dramatizes this drawback to having absolute immunity for people?
Well, I'll give a brief answer.
Yeah.
It's not even my own answer, but I mean, if you look at the opinion, for example, in Zarin versus AOL, which is a post-230 opinion, now you have a situation where Matt Drudge is publishing something for AOL. He's getting paid by AOL. It's defamatory as to Sidney Blumenthal. Sidney Blumenthal sues AOL, who has not only made available this information that causes this harm to Blumenthal, which we might say, well, they make available a lot of information, but actually paid the guy who wrote it, and under 230, there's no liability. Now, the judge who wrote that opinion, you kind of get the, you know, how difficult it was for him to write the conclusion that was required by law in that case. So I think we do run into these situations where in a privacy world, people might say maybe 230 is going a little bit too far.
I mean, also has to, two other things I can say quickly is, I wouldn't, and again, I honestly don't know enough about 230 and so I'll just state this as conjecture, but as I understand it, if it really is that offensive, there are extra legal things we can do. So hopefully, moral suasion and norms will convince them to take it down, even if it's not threat of lawsuit.
The market.
Right.
Yeah.
But not even the market. It's their appeal to their decency, really, right? I mean, it's that bad.
That's in the market. The market does
Yeah,
that.
the market does that. Not always. Not always. I can give you some counterexamples. And then the second is, I'm all for, I mean, this treads on different privacy interests, but I'm all for aggressive, litigation against the people who actually committed the privacy harm. And so I can't say if Lemley's still in the room, but suing the people who posted on AutoAdmit, and even using some tools that pierce privacy in other ways to find out who those John Does might be. I mean, that might be appropriate when the harm is sufficient.
So the problem we're grappling with here, I think, is really primary liability, first party liability. And the reason why it's hard to grapple with is because privacy is essentially cultural. Both my colleagues at one point or another have talked about privacy harm, but that presumes a standard that isn't in evidence, which is the existence of harm. A lot of people are thinking about it. What are privacy harms? Kind of, how do we get to a privacy harm that we can convince a court or a legislature to adopt? It's hard to do that with privacy without exploding the concept of harm. So that work is going on, but I don't see a lot coming from it so far. Privacy is essentially cultural. It's still very much in flux. Technology is changing, and the way people act with reference to technology is changing. So kids today, they just don't protect their privacy, right? Us old people say that. But in fact, kids are creating a whole new set of social norms that reflect the technology that they're working with right now. And the technology will change and those norms will change. So setting them in stone with a with any kind of legal standard that this is a privacy harm, this is not, is probably a mistake. You know, to illustrate the cultural dimension of privacy, put on your anthropologist hat. In Privacy and Freedom, Alan Weston's 1967 book, which I think is really important in this area, he talked about a study of a tribe in North Africa called the Tuareg, who are a Muslim tribe, but the men wear veils. An anthropologist went out there and lived with them for 1.5 years, 2 years, and he studied the way they wear their veils. When you look at things from an anthropologist's perspective, you can start to recognize things like that in your own society. We have all kinds of privacy-related things that we do. The clothes we wear, how we button our clothes during one meeting versus another, the sheerness of fabric, hemlines, all these things, and that's just in clothing. Buildings are devised with privacy built into them or built out of them, and so on and so forth. All these things, thousands of decisions per day, people make that vary with their privacy interests. And so to try to boil them down to a legal standard or a form of harm is very, very hard to do. That isn't to say that it won't ever happen. There will be consensus around privacy, and it was formative in the privacy torts, but there hasn't been much action in that. But that may continue to reflect the cultural expectation.
Well, 2 questions. Oh, go ahead, Mark. Sorry.
Well, I mean, Jim said 2 things, one which I agree with and one which I wildly disagree with. And since it's toward the end of the day, let me start with the controversial.
Good.
We'll do a little tag team here.
Peace.
So, I mean, you know, look, the anthropology of privacy is interesting, but to say in, the year 2011 that privacy as a legal right isn't well established, or that there aren't well-known international norms, I think is just wrong. And any, lawyer here who's doing any practice in this field in the United States, whether it's with, medical records or EU companies or Asian businesses, will know that immediately in any collection and use of personal data in the business environment, there are a whole host of privacy laws and compliance issues. It is a huge area of practice. Now, I think what Jim is speaking to, which is an interesting point and something certainly we need to think about, is what's happening in the Facebook environment. What's happening in this new environment where people are exchanging information from one person to another, right? And let's also acknowledge that as we think about the Facebook environment, data is being collected and being used also by the company for other purposes that can pose its own regulatory concerns. Maybe it's being used for commercial reuse, maybe it's being disclosed to law enforcement on a Fourth Amendment or Fourth Amendment-like standard. Those are interesting questions. But I think what Jim is speaking to, which is kind of fascinating, has to do with the interactions between people and the disclosure of personal data. Now, my view here is that this is the area where I actually think that the claim for liability against the intermediary should be at its low point. In other words, to the extent possible, I actually don't think Facebook should be mediating relations between people, more than the telephone companies would mediate what people say to one another over a telephone network. Now, it's a little bit more difficult because obviously we're publishing to a larger audience in the online environment of social networks. But Jim's point's an interesting one. Kids may end up disclosing information in their generation that we might not have, and maybe we'll come to understand that as reflective of this new environment. But to say that that doesn't mean that we have well understood privacy standards, I think would be to draw the wrong conclusion.
So let me change, did you want to respond to that, or can I change that?
Well, I'll just briefly respond. I think the standards that we have, the best privacy protection is from laws that don't have the word privacy. Contract law is good privacy protection. Tort law, including battery, is good privacy protection. Property law is good privacy protection because when you go in your house, shut the door and pull the blinds, nobody can see what happens in there unless you let them in. These are all good privacy protection. So it's not to say that there isn't law relevant here. It's just a lot of privacy laws don't actually do the trick.
Okay, so actually a much related point, and I'm going to start with Paul, please. So you can keep all this stuff in your house. You can keep all of your notebooks and all of your work product and everything else in your home. Or increasingly, you can keep it with a third party. you can keep it with a service provider. And maybe it doesn't really even change your expectations about it. That is, you no more think that the government or some third-party litigant is going to get at something just because you have sorted elsewhere. Perhaps you do, perhaps you don't. So the question, I guess, is what responsibilities do intermediaries have, Paul, in terms of in their role as custodians of user information? And are the safeguards enough? And are we seeing enough companies push back when they get requests for user information?
So there are a couple of things bound up in there. I mean, most of the question was focused on law enforcement. So we were mostly talking about company, person, right, in the first set of questions. Mm-hmm. And now we brought in this other thing, the law enforcement aspect of that. So I'll focus my answer on that. And so as a matter of just straight law, as I'm sure many in the room know, it isn't clear, but there's at least some suggestion in some courts that our expectation of privacy is greatly diminished when we do something like that. And so as students of the Fourth Amendment know, you've got this series of cases that say when you share, for example, bank records or telephone dialing records with third-party companies, you have no Fourth Amendment right. And we've actually come in with statutory rights to replace what the courts have taken away in the Fourth Amendment. So, there's been a lot of strum and drag over the years. Wow, I didn't even use the German accent on that, right? Strum and drag, is that? On whether this would apply to Gmail and whether this would apply to Google Docs and to all of the things that we're doing now in the cloud. And so not too long ago, in the Warshak opinion, the Sixth Circuit, I think finally and categorically and quite persuasively said, you were upset over nothing, that as a matter of legal doctrine, you will recognize that something different is happening when you're storing your email messages with a company than when you're merely telling them to route a phone call using the numbers dialed. And to be honest, I mean, I could claim to be this person who could be the future. I'm not surprised by this. I mean, I'm glad a court has finally said it. I hope some of the anxiety over Fourth Amendment protections in the cloud disappear, because I think ultimately 10 years from now, 20 years from now, courts are going to understand that this isn't very different in the House. It's going to take a little bit of kind of mental gymnastics. It's going to take some strange analogical thinking. But I think it just makes sense. The Fourth Amendment has to expand to take account for the different ways technology is re-architecting the way that we store things. So that's one answer. I mean, the other answer is you've got the statutory overlay, you've got the Electronic Communications Privacy Act, which I think in some strange ways set the ground rules for when companies, for example, can share information with the FBI with something less than a search warrant. Most people in this space who've taken a hard look at this agree that the rules are really not well tuned to what's happening on the internet today. When I say most people, I mean everyone who isn't part of the Justice Department seems to agree. And so I hope change is coming in that realm, and I'm sure a lot of you know about the Digital Due Process group that is trying to bring about kind of a normalization of those rules. So I think actually I'm a lot more optimistic about this now than I was 10 years, and I think I'm a lot more optimistic about this now than some colleagues are.
I'm going to let Jim also add to this. I want to put a note of pessimism.
Sure.
Yeah. So I mean, it's not like we all expect that the government's going to go knock on. I mean, I don't think the government's going to try to get my stuff. I just don't think I'm interesting enough of a person that they're going to be looking at it. But one of the things that I noticed is that there would be absolutely very little way for me to know. Yeah. That is, the government doesn't have to. I mean, government actually can not tell me in under many circumstances. The company has very little obligation at all to tell me that this is a possibility and to change my mental model so that I think of it more as being different from the home. Much less tell me that because my email happens to be 179 days old, tomorrow the standard of law that attaches to it. So, I mean, I guess you don't have to respond directly to this at all, but I mean, are we asking enough of companies? Should companies be doing more to change people's mental models about the actual state of the law?
I ask companies to do more and say more about it, but it's not in their interest to do it, and so they do a little bit. And
what about Twitter getting this big, thank Twitter movement around the fact that they push back against the?
I mean, largely I think those are cosmetic. I don't trust companies to protect my privacy. I think the law has to protect privacy, and there's where it fails. I want to say, because of the good things I heard from Paul, I hate the cloud. I don't think ultimately we'll end up with cloud services there. That's a technologically contingent circumstance. In the future, we'll be able to do storage at home, where we actually control the storage ourselves. Hopefully we have mesh networking so that we don't have to use centralized internet service, but I'm looking down the horizon. The thing that's wrong with the cloud right now is that it's a marketing term that deceives people who should know better into thinking that data that's out there is just kind of going to rain down across the plain. And I think this marketing term, which is fine for those purposes alone, is being used to characterize the data about us that we share with specific providers for specific reasons, and that they store or process or whatever it is, that they can do with it whatever they want. Law enforcement comes in and says, well, it's in the cloud, so that's just up there. No, in fact, the data that we put into different cloud systems, they owe us the privacy promises that they've made. Now, in turn, if they pass along to others, that debt to us doesn't break. So I think it's very important to think about it that way. And the law is a shambles. The third-party doctrine, which Paul referred to, grows out of some Bank Secrecy Act cases where the Congress required banks to collect information on the chance that it might be used for law enforcement purposes later. A legal challenge to that failed because the government hadn't actually collected it. Subsequently, the government used that information, and a legal challenge to that failed because the information had already been shared with the third party. So how can you say you had a privacy interest in it? That's really because people have interpreted the Katz case wrongly. I'm here to say that everybody is wrong. Read the case. You should know that the reasonable expectation of privacy test comes from Justice Harlan's concurrence, which is not required for the case to have come down the way that it came down. The actual case says that if a person has protected the privacy and information, it is constitutionally protected. I've got a law review article in the American University Law Review called Reforming Fourth Amendment Privacy Doctrine, where I go through the actual language of the majority decision in the case. It doesn't create this strange gloss about reasonable expectations of privacy, this objective, subjective test that's done so much bad for privacy law. Getting away from Katz, though it was a better decision than the prior one, getting away from at least that interpretation of Katz would be very good for protection of our data in the cloud or wherever it ends up.
Marc, do you want to weigh in here on...
I mean, and actually just to fall into Jim's point, I'd be happy to go back to the Brandeis dissent in Olmsted, because then you get Fifth Amendment protection too, and some data would simply be off balance. So for us, that's a great outcome. But I think there's a very important dynamic for people to understand in the privacy realm. I mean, law tends to preference decisions of the Supreme Court. So we talk a lot in terms of the court's rulings about the scope of the Fourth Amendment. But of course in Washington we also think about the role of Congress and the force of statutory law. And in the privacy realm in particular, I think what you see is that when the court has failed to establish safeguards for information, Congress is able to do so under statute. And this in fact is what happened in the third-party case of California Bankers Association versus Schultz. We subsequently got the Right to Financial Privacy Act, not the Bank Secrecy Act that you referred to. Now just a word on ECPA, because I think Congress had the insight 25 years ago, which I guess the Sixth Circuit had in the past year, that stored communications are entitled to some privacy protection. And I know it's not so much that people are trashing ECPA these days. I think updating it is right. But I think it's very important not to lose sight of the insight of ECPA in Congress in 1986. Because you see, up to that point in time, the concern for protecting communications was the interception of an oral communication in an analog world, right? And in the early 1980s, what's beginning to happen is the emergence of digital networks and email communications and stored communications. I mean, this is really where the question of liability arises. So if you want to offer a business, as CompuServe and Prodigy and some of the others did in the early 80s, and you're providing to business customers a communication service, people actually want to know, not just by contract, because that doesn't help you when the government comes knocking on the door, what will be the circumstances under which your service provider will make your information available to someone else. And EXPA comes about in part because all the parties agree on the need to clarify the rules for access to the stored communications in the emerging email environment. I think that was an enormous insight. I think it actually helps us understand how we would provide a similar regulatory regime in the cloud computing world, which looks actually surprisingly similar to the initial effort that Congress undertook in the early 80s. Updated, yes, but the model's correct. The model recognizes the emergence of services based on stored communications. You'd agree with that one?
No, I would. I mean, I've got a quick follow-up, lest someone accuse me of actually being optimistic about something having to do with privacy. I mean, the optimism I expressed earlier was about the state of the Fourth Amendment and third-party doctrine. I don't think we're going to have to worry about that for long. I really think Warshak is going to become the law of the land throughout the circuits. But you raised two really important notes of pessimism in your follow-up, and I agree with both of them. Number one, you've got this weird layer of secrecy, not just in the companies themselves, but in government's role, right? And so when I was at the Justice Department, I was in a unit called Computer Crime and Intellectual Property Section. We had people doing normal, boots on the ground law enforcement, where we tried to find criminals, and then we had people who I refer to as on the dark side, who sat behind locked doors and whispered a lot. And so I fully believe that there's things going on behind those locked doors that we don't know about, that will alarm us, and that will come to light someday. So that's pessimism number one. But number two, this is probably the more fundamental thing, and it goes to Jim's prediction about the cloud disappearing, which I'd love to explore some more. I don't know if I agree. We store a lot more information than we ever used to with third parties. So that's a big change in the dynamic. The fact that Google, if I click on the latitude button, will now track where I go and keep some sort of record of that, and that my cell phone company keeps a record of where I go, and that strange little things I used to say by the water cooler for some reason now get saved by Facebook. So we're creating a permanent record where we didn't used to, and that's going to affect us in all sorts of profound ways.
So Jim wants to mention this, but I want to jump in with something too, and feel free to just respond directly to Paul there. But a lot of interesting services have come out. I don't know if people have seen this, but like a lot of interesting services have come out over the last year or so. It seems to be the entire purpose of the service is to do something that is already happening more privately, or to help you get a handle on privacy, or something like that. Down to things that will like keep all of your information in this lock, but just like to bend the bodyguard that keeps all of your information in a lock. So is there a role for the market to step in here and for people to change the way that they do services? This is why I'm coming to this point. In a way that actually safeguards information better, not only from the government, but from one another. I mean, I heard of an example recently, sorry to go on a tangent quickly here, but where iTunes was doing this thing where if you would gift a movie to somebody else on iTunes, I don't know if they're still doing this or what the deal is, iTunes would tell you whether the person already had the gift or not. So that you could figure out what videos, for instance, your friend had by virtue of giving them to them. Maybe you don't want to sit there and spend $40 to figure out if your friend has X, Y, and Z video. But I mean, that strikes me as a terrible way to architect a system that permits that kind of thing. But then, does that differ in kind from, hey, let's store everything in this cloud unencrypted that the government can get?
So I want to say one thing that riffs on what I heard from both Marc and Paul, and then get into market stuff. I'm with the Cato Institute, and we like markets. So an interesting thing that you heard, I think there isn't a lot of love for imposing liability on third parties, or much of anyone. Certainly not third parties. We should also be wary of creating immunities. That's the other side of this, or having immunities. The dangerous actors in privacy these days are the immune actors. Notably, governments, who are immune from liability for their privacy violations, and the handmaidens of governments, who are sometimes made immune. I think of the telecommunications service providers who were immunized by Congress after the massive warrantless wiretapping program. So at the same time as I'm not for liability, neither am I for special immunities either. And so watch for the immune actors. as being dangerous to privacy, maybe as much as those who don't have liability or more. As far as the market goes, you know, a lot of people talk about privacy business models and so on and so forth. Many years ago now, I did a panel with a guy named Dave Kramer, who was here earlier in the day, down in Mountain View. And someone at the end of the day said, so it was for software entrepreneurs. So where's the money in privacy? I'm looking up and down the panel, it was all lawyers. That's where the money is. It's in regulatory. Really, privacy is going to come from people understanding how the world works again. We learned how to keep our stuff private in the physical world through thousands of years of training. And you hear parents tell their children, no, pull up your pants, that's your private area. And that's the kind of training that people get through life in the physical world. A new world has emerged over the last 15 or 20 years, and people don't yet know how it works. So they can't teach their children how to, in a digital sense, pull up your pants. People are walking around online not aware of the information they're sharing.
With their digital pants down.
With their digital pants down. And so it won't necessarily be somebody's business model. It will be time passing that gets people to understand how these things work. And so when I want to communicate with a certain party about a certain thing, I'm going to not use my usual IP address. I'm going to use a different email address. I'm going to have to take lots of steps to protect that privacy. So there will be interstitial business models. For the most part, privacy is what you call an intermediate good. If it's part of a service, that's good, and you're going to get a marginal benefit to that service, but people don't buy privacy separately. So they buy it the way they buy a fireplace in a house. They don't go around shopping for fireplaces. They buy a house. Does it have a fireplace? Okay, good. Here's a web service. Does it have good privacy? Okay, good. I'll buy that one instead of that one. So I kind of doubt the privacy business model idea as a freestanding thing.
I agree with that, actually. I mean, I don't think that, and this is something that history has shown us, I don't think that markets for privacy services at the user level work. Part of it is that there's none of the network effects that people need in the online world for their email, for their web visiting, unless others are also using the same standard, which immediately leads us to the point that the really big decisions about privacy operate on the macro level. Does Google, for example, routinely encrypt Gmail? The decision to go to HTTPS, which they did after the China hack, was huge, right? Facebook has recently made HTTPS available, but it's not the default.
Do you understand what that means? I mean, yeah.
Well, I'm assuming most people here will. I mean, you know, to be able to securely communicate between the client and the server in the web environment solves all sorts of privacy problems. It doesn't solve the third-party problem, but it does solve the problem with respect to communication. Same thing, by the way, I mean, the emergence of online transactions, the fact that you can buy from Amazon or eBay or iTunes has to do with the fact that very early on, you know, companies incorporated Diffie, Element, RSA, and the techniques that would make it safe. So for someone to put their credit card number, account name, and expiration date, you know, off into the cyberspace and end up getting a book or YouTube or whatever it was they needed. So I don't think that the markets work, but I do think there is a very interesting question here. What is the relationship between regulation and business practice? Now in the US, the view is we would prefer to innovate rather than to regulate, right? I think there's a view in Europe, at least on privacy issues, that says we will regulate to encourage innovation. In other words, if we say privacy is important and you can be held liable if your user data isn't properly accessed, that will create incentives for companies to solve that problem. And the companies that are best at solving that problem presumably become most successful. But that view of the world, frankly, is premised on a belief that regulation helps enable innovation.
Like carbon emissions. Oh, please.
So Marc purported to agree with me, and then said twice that markets don't work.
But you said that. He was repeating you. They don't work for privacy, don't they? Isn't that what you said?
I described how they work for privacy. They're an intermediate good. You're not going to have someone say, here's my privacy service, pay me $10 a month for it. But a service that provides privacy will gain over a service that doesn't provide privacy.
Is there an example of that?
Not at the top of my head, but actually here's an example. And it's also an example of how people learn about products. no one in the real world is like us. We read privacy policies and debate whether it's an appropriate privacy policy or not. Human beings learn from their friends what service they should be using. Sometimes they make bad decisions or decisions that Marc doesn't like, which is a more accurate way of describing them in the privacy area. Markets are slow, and sometimes they converge on things that Marc doesn't like. Sometimes they converge on things that I don't like. But here's how people learn about stuff. 10 years ago, my dad said, you should use Amazon. It's cool. And so I went and started using Amazon. And that was one example of someone who looked into it, knew a little bit about something, said to another person, go ahead and use that one. And that's how information about products and services propagates itself. It's not that one individual lone consumer comes up to a new website and says, well, I need to learn about the privacy policy, and I need to learn about whether it's, does suitably what I need to be done. There's this great communications mechanism that's gone on long before the internet, that's much stronger with the internet, where people talk about goods and services. They talk about privacy consequences. They don't always come to the conclusion. But this is a marketplace that works, even if it isn't converging on perfect privacy. It's choosing sometimes convenience over privacy, low prices over privacy, fun over privacy.
Let me add a data point there. I don't know if people are aware of some work out of Carnegie Mellon that suggested that people would be willing to buy something for a little bit more from a website that could be shown to have better privacy practices. That basically got more green bars on privacy, and according to this one metric, and so people were actually willing to pay a little more. So, I mean, this sort of brings me to a final question that, in a sense, is the furthest away from the idea of liability for intermediaries, but dovetails quite well with what we're talking about, which is, these companies, search engines and ISPs and browsers, actually serve as intermediaries in another way. That is, they mediate our experience of the internet. And by virtue of doing so, does that give them a special role? So, for instance, Mozilla sends a signal now not to track. Microsoft recently came around to that view as well, but has another implementation, and Chrome has a third. Is that what role does that play? In other words, should these companies like browsers who stand in the middle between web pages and users, do they have a special obligation to try to solve the space, and what are their tools available? And maybe start with Paul.
Yeah, no, I mean, I don't know about obligation. That might be a little bit stronger than I'd say it, but we're at Stanford, and so code is law. I mean, right? I'm fascinated by the Mozilla example, and I'm fascinated by the role this very center had. And I see Jonathan and Arvin are both in the audience. I mean, two of the architects of the way Do Not Track is being implemented, right? I mean, architecture is destiny on the internet, and Mozilla has now created a little bit of architecture with the help of some people at Stanford that could really meaningfully kind of invert some of the ways we think about privacy. Now, I totally disagree. I thought I agreed with you, Jim, but I guess we ended up disagreeing. You were describing privacy as an intermediate input into the markets. I mean, I think there's a lot of really good writing on how privacy is something that's subject to all sorts of systematic market failures. And so when we look at the net amount of privacy that we get from our market, it's hard to, I think, make the claim that this is the optimum level, or this is the preferable.
Can you give an example?
Sure. I mean, the fact that, we claim in the abstract that privacy is the most important thing that we want, but when faced with a tiny little diminution of our privacy, we often will give it away because the violation's happening in an accretive way, in secret, that you don't know about until it's too late.
Not a market failure. It's not a market failure. Now, that's people's bad judgment or misunderstanding about how this stuff works.
Right.
But that's not a market failure. That's people's failure to comprehend. And that's the most important solution here, is for people to understand how this stuff works.
But there's the market failure there, which is people need to understand how this works. I mean, the world is littered with the notice and choice regimes that, someone heralds as the great new day of consumer understanding of how their privacy is at risk. And then a year later we realize, no, we didn't understand what the hell we were agreeing to there either. I mean, there comes a point where we start to think that there's just a systematic hurdle to letting the market do things with privacy. So I wanted to, the reason I went to this is because Do Not Track, we built it, but I think we need a layer of regulation behind it, and whether that's congressional statute or aggressive FTC action, that says, you know, carrot, stick, however you want to put it in there, but a subtle input into this broken market that will actually get websites respecting do not track, using do not track a little bit more than if we just let the laissez-faire reign.
So, sure, yeah. And do not track is a great issue, because a lot of people think that putting a do not track signal in the HTTP header is fixing the problem. What it's doing is transferring the problem from the coders to the regulators. And the regulators are going to decide what it means when a do not track signal shows up in the header. And that's going to apply to whoever the regulators decide it's going to apply to, because Section 5 of the FTC Act is very broad, applying to all commerce in the United States. So we haven't solved the problem at all, just shifted the battle to another area. If you want to protect privacy online, sorry to not offer you an easy answer. The answer is not to share information online. That is to limit the information that's in the header. Maybe it's to scramble the header so that fingerprinting won't work. That's to do a lot of different things, and that war should continue, because otherwise we punt on our privacy and we get federal regulators saying what our privacy is going to be. And do you know who's represented in Washington better than you? All the privacy invaders that you're so worried about. So they're working those agencies all day, every day. People in those agencies go out to work in lobbying firms for those agencies. So careful what you wish for. If you think that the do not track system using HTTP headers is the right way to go.
So what if I don't want to be tracked today without regulation? Right? How is this not market failure? I don't want to be tracked. I'm announcing it right now. I want cookies to work so that I can do things like have state on my website, but I don't want to be tracked.
So the market allows you to choose which websites you go to. The market allows you to refuse cookies from all websites. I select among cookies. I'm a little bit of a persnickety about it. I select what cookies I'll share with what websites. These are things you can do now.
No, but I just don't want to be tracked. I want to use things. I want the New York Times to remember some of my preferences, but I don't want to be tracked at all for behavioral advertising.
You probably also want to go outside and not have people remember that they saw you there. But some of the realities we're dealing with is the fact that we have to share information. You have to let photons bounce off of you and fall into other people's eyes if you want to go outside.
I don't think privacy. I think the interplay of privacy and architecture is a really, really fascinating, important one. And the internet we have today allows certain types of things that I think we very, very honestly can agree are privacy violations, not because of some grand destiny, but because of some choices made by engineers early on. And I think that if we have something that a lot of consuming public would really want to use, and if the engineers could build it and give it to us, and if we need a little layer of regulation to make it actually work, I don't see what's wrong with it. I think it's
the thin mint. It's wafer thin.
Just a little bit. All right, so Paul, you have to pull up your digital pants and move on. But so Marc, I'm going to give you the last word on this, and then I'd love to open it up to audience questions. I can't believe we've already had an hour here. But please, yeah.
Jim just said so much I disagree with. I think I need an hour myself to answer everything. But apparently there's this mythic world out there called free marketia, where all these things seem to solve themselves. I mean, just by way of example of the problem with that worldview, when you take a look at what happened with the Facebook privacy settings, where people made decisions, they exercised choice, they said this is what you do with my photos, this is what you do with my wall posts, this is what you do with my email, and then Facebook said, thank you very much, we have some new products, and now we're going to change all that and disregard it. It's the absolute collapse of any unit that says self-regulation works, because unless you have a mechanism to at least enforce private contract, these actions become meaningless. And the significance of Carnegie Mellon and Alessandro Acquisti's work is to say that people are quite rational. Over time, they'll stop reading privacy policies because they know they're meaningless, and they're meaningless because they're not enforced. But I want to come back to the relationship between innovation and privacy, because Jonathan is here and it is Stanford. And I think privacy sometimes gets a bad name in the innovation world. I mean, we're seen as sort of the obstacle, the thing that slows stuff down. I think, in fact, it's quite the opposite. I mean, you would not have the commercial platform that the internet is today without the bedrock of security, secure transactions, and authentication that makes all this commerce possible. It just would never have occurred without those building blocks in place. And I think when we go forward and try to think about some of these technologies that promote privacy, in the absence of some clear legal direction and some clear regulatory obligation, it's not going to happen, because there's simply no incentive to respect those preferences, whether they're in the HTTP header, whether they're on Facebook or elsewhere. And, that's one of the things that seems almost obvious at this point.
All right, so I think we're going to have to, we'll probably continue the conversation to some extent. We really want to open it up to audience questions. And I'll just start a queue, but it looks like there's a lot of, can we start with you, sir?
Yes, I had a comment and a question. On the Google Italian case, I was on a panel about a year ago with a very prominent lawyer from Milan who said that the case was really an aberration because Google's lawyers first tried to stiff the process. They didn't, they tried to stiff the authorities, and then to blow the whole thing, you're supposed to raise a jurisdictional issue the very first moment in the case, or you've waived it. And they didn't raise the jurisdictional issue, and he said if they had, there would have been no jurisdiction. But on the cloud, here's my question of the panel is, you remember Ray Kurzweil about 11 years ago down here at Stanford, Kurzweil predicted that in, I don't know, 2020 or whatever, sometime, there would be 3 computers in the world. And there would be no laptops, there'd be no PCs, and there would just be a little chip in your contact lens or your glasses connected to one of these 3 computers, which computers would, according to Kurzweil, have more computing power than all the computers today put together. Do you see that as really happening? And if so, how will it impact on privacy?
Well, I think it is. I don't know if it's 3 or 7, but I think we're talking about a small number of cloud servers. And in my mind, and I've also been around this for a while, this period in computer architecture feels to me like the counter-revolution. In other words, if you remember the 60s, there were big computers controlled by large institutions, and if you were lucky, you got a little bit of time to work on a project through the 70s, and then something sort of miraculous happened in the late 70s and early 80s. It was the emergence of the personal computer. Suddenly the computer became a consumer product. You brought it home, you had your software, you had your data, it was within your control, yes? Now we're seeing the data and the applications move back into the middle. And here we're talking about what's going to be accessible to us, tethered on the outside. I think it's and from a privacy perspective, which is your question, yes, I think it's very, very troubling. Because of course, in the last generation of architecture, the data, the applications were under your control. That's changing very dramatically.
I agree with Marc, and I think that your question is a good one. It reminds me, I referred to this book, Privacy and Freedom, by Alan Weston. In the book, he muses, this is 1967, he muses, what if one day individuals have the computing power that governments and corporations have now? Of course, the personal computer came along and did change the architecture. I agree with Marc that it's shifting back, and the cloud is shifting back, and that has effects on not just privacy, which is why looking down a similarly long horizon, partial response to Paul, looking down a similarly long horizon, I look forward to the day when the computing power and the storage power maybe flows back out to the edges. I think it's also important to think about where internet service is. Right now, internet service is one of the few bottlenecks that remains. You've got to go through one of few ISPs in order to get online. And my hope is that again, over a long horizon, we move toward mesh internet service so that I can truly be anonymous and not have to work through an ISP to get online when the time is right. So watch mesh, look for mesh, root for mesh.
Root for mesh. Did you want to weigh in that question?
I mean, it's interesting. This is why we're kind of outside the privacy topic, but if you had asked me 10 years ago to predict, and I looked at the curve of storage getting cheaper and bandwidth getting cheaper, I'm not sure I would have predicted the cloud. I might have predicted ever more powerful personal computing that dealt with some of the viruses and bugs and other things that were plaguing us. So I'm not sure how we ended up on this weird branch that we're on. And I don't know for sure if I can predict that we're going to ever leave this weird branch.
It's only got, I don't want to take too long, it's only a guess of mine, but the economics of cloud right now exist because it is still expensive to run storage. So you're better off having professionals run your storage If server
It's
blades.
the
comes-
storage though, it's expensive.
Was it expensive?
It's not the storage, it's the maintenance and the reliability and the lack of virus and things like that.
Total cost of storage is relatively high. Once it's purely commodity, you can have storage any place, and your preference should probably be to have it local, to have it in control of your own organization rather than outsourcing. Perhaps just over time we'll find out.
We have another question here.
Yes, one serious impediment to having the market work here is that, it strikes me that, so setting aside all the behavioral biases that are now being sort of pretty well documented, there's just a mismatch in time between the time that you need to make the decision and the time where you appreciate the privacy implications, right? And I just wonder, I sort of go back and forth on this, is that a more serious problem here than it is in other places? That the implications of having wished you had cared about privacy, right, that now can't be undone, right, for some of the reasons Paul talked about, there's just the mismatch in time problem strikes me as a more serious one here when we start talking about online.
Well, I testified a couple of years ago before the Senate Antitrust Committee, and this is probably a Google-related matter, and people were interested in this question. They said, why isn't it that people can't make choices, about privacy policies, just like they do about cars in terms of mileage or ice cream in terms of, calories versus frozen yogurt. And if you think about it for a moment, it becomes pretty obvious what the problem is with privacy. These metrics don't exist, they're not stable, and they're not meaningful, right? So if you want to buy a car, you can say miles per gallon, this is 23, that's 36, that's information that you can act on. And you can look at the calorie count in the frozen yogurt and the ice cream, and you can make a decision, right, if that's a factor for you. But you can't do that in a meaningful way, I think, as a consumer. It's a little different in the B2B world. Businesses are a little bit more sophisticated. They'll make more informed decisions. But I think the answer to your question in part, and again, this goes back to Acquisty's work, there actually aren't meaningful decisions to be made. And it's because of that that people understand it doesn't make much sense to think too much about privacy, which is an unfortunate outcome, by the way.
The premise of the question is people are making bad decisions. We recognize better than they do what the consequences of their decisions are. So postulate a person who, and this is hard to do on the fly, postulate a person who takes the steps that protect their privacy well, and to do that, they give up $1 a week in benefit. Add up a 30-year time horizon, at $1 per week, they've lost what amount of money? Who does math? No, nobody, lawyers. But so they're
$1,500.
however much worse off, use the time value of money to add to that, they're worse off at $20,000 at that point because they protected their privacy. They would have been able to get important medical care with that $20,000, or eat better food with that $20,000, or buy a safer car with that $20,000, and they die in a horrific accident. How do we know?
A hyperbolic example.
How do we know that our decision making is that much better?
We do that all the time, right? We tell people all the time, look, you're not going to appreciate the value of the education, but you still have to get it, right? And you have to get it, and even though you're not going to appreciate the value until way out in the future. So it may be that that's a generalized problem, but I guess it's one that we make choices for people all the time because we think they don't appreciate what's good for them. And so maybe you're just more averse to that generally than I am, but what I'm asking though is, it strikes me that in this case, it's a particularly compelling argument, right?
Education is very costly. I could have had a Porsche, but I went to law school.
Yeah. So
You bought a Porsche.
I made a lot of money in it. So just a good concrete example and Marc mentioned Senator Acquisty's work about how you get the benefit of sharing immediately. The detriment though takes a while to sink in, right? So one example is people who use this service Blippi with a credit card, where you go and you buy things and it tells the world.
I don't know what the benefit of that is.
Yeah, so people go and use this service, and maybe you can anticipate, oh, well, gosh, maybe they'll leak my credit card number, which actually turned out that a security flaw, and people's credit card numbers were available on this Blippi service. And to those people I say, well, you got what's coming to you. But what about the fact that think about how much easier it makes spoofing somebody, right? You get all these emails all the time, you're like, hey, this is Citibank about your account, click here. And you're like, you're not Citibank, I know you're not Citibank. Versus this question of if you're using Blippi, I'm Amazon talking about your purchase on this particular date of this particular amount, click here. you're seriously going to do that, right? And I cannot imagine that we could come up with some super consumer who's going to be able to parse those kinds of downstream consequences. I mean, it's my own editorializing, but it's just like, you know, it is just really, really complicated, and companies do everything in their power to make it really fun and attractive for you to share this information. And I cannot, I always sort of the myth of the super consumer. I'll allow you to respond to that if you want. But.
So there is no one super consumer. There are lots of consumers who are communicating with each other all the time. They're more empowered now than they ever were. Now, obviously, new services that do silly things like this, I don't know anything about Blippi. Yes, if you are broadcasting your purchases and someone uses the thing you broadcast to phish you, the first 15 people that get that will suffer a phishing attack. But before too long, they'll learn that broadcasting your purchases make your purchase information no longer private. And so when someone comes to you and talks to you about it, it could be anybody. So I think people do have good common sense. It's slow in coming. So again, offline, we learned pretty well that if there's a postman sitting on your stoop and he's rifling through open mail and he asks you where the nearest drugstore is, that's probably not actually a postman. So offline, that's really easy. We're getting better at recognizing that when we get something sent from a strange email address and it asks us to download something, that we shouldn't do that. Now that's happening more slowly than I'd like, but I'd much rather have potentially innovative services, I don't know if Blippi is one, out there trying to come up with new, exciting, interesting ways of interacting and saying, no, there's no possible way that anyone could ever want to do that. It's silly and stupid. Consumers can't handle it. Consumers rise or fall to your expectations. They rise to your expectations or they fall to your expectations. So set them low.
You in trademark law about that?
We have time for I think one more question, and then this has gone so fast, and then we're gonna. So yeah, please.
I think in response to Mark's point, I don't think it's so much that there's a time gap between when people make privacy decisions and the effects, but people make very sort of discriminatory privacy decisions. They decide that they want to share a lot of things with a lot of people. They want to tell this website what they want. They want to tell their friends on Facebook what they did last night. They want to do this. They want to make public to a whole bunch of people, rationally deciding and buying into making things public. And then they look at other uses that people make of things they've already deliberately decided to make public and go, oh wow, wait a minute, you're now sticking all that together, and because of that you can advertise to me? I want to opt out of that. Well, that's great. I would want to opt out of that too. If you would watch all the ads for me and I could still get the internet for free, I'd take that deal in a second. Right? The problem with an opt-out is a free rider issue, which is, okay, we all opt out because we don't want advertising targeted to us, because we wanted to only share the things we wanted to share with the people we wanted to share, and all of a sudden now nobody's giving us free internet anymore.
I mean, opt-out numbers are likely to be low, but I get the.
Hopefully, because otherwise the whole system breaks.
Yeah. Okay.
How do you know that, Ryan? How do you know that?
There's a study out of Stanford that looks at how often people use in-private browsing, for instance, and they see the percentages are really low. There are other studies that show how often people opt out of particular things, and I can send you a list of that. I mean, it's so awesome that there was a game company in the UK, as you probably know, that had this terms of service that said, unless you opt out of a terms of service, we have the rights to your soul in perpetuity. Okay, and 10% of people opted out because some prominent blogger actually went out and put it out there and said, hey, this is an opt-out, you should opt out of it. People don't opt out. That's
that was a good deal.
What's the rule against perpetuities?
The question is, why do you ask that? I mean, so why are you actually concerned about it?
But you're making the assumption based upon the context that we currently live in, where that opt-out happens in a more organic way.
Yeah.
And in the context that a lot of people want to move, it's the new paradigm. A lot of people, I'm sorry, I'm not here. A lot of people basically want to say, make it a cost-free opt-out under a very simplistic sort of do not track or some other sort of privacy regime, whatever it may be. I think that totally changes the ballgame. and leads to exactly the problem that gentleman strays over there. I mean, that's the problem I have, is that you're operating under a set of baseline assumptions I don't think hold in the new world that I think some people want to move us to, including you.
Could it be? No, I mean, look, I'm not sure. I'm totally. Go ahead. Sorry, Rick.
Yeah, just to put a little to work with that, and just to put a little meat on the bones on that. It doesn't depend on interface, right? So
say that again.
It depends on interface. So if the question is whether you use in-private browsing, whether you opt out of a particular website, that may be very different from the situation that Adam is talking about, where the browser has been designed to offer you a single box that says, I do not want to be tracked, right? Where, and there's a consumer education campaign that beats it into people's heads that everyone should click that box. Because that is what people have in mind when they draw the analogy to do not call. And their metric for success is half the population, or 70% of the population, opts out. Right?
Wait, there's a consumer education that's forcing people to...
No.
This is the free market.
All I'm saying is, you can't leap from, this is what Adam was saying, you can't leap from current opt-out rates to the assumption that all opt-outs will always fall below the level where it's a problem.
But this is drawing the wrong conclusion from do not call. I spent a lot of time on that, 20 years on that. Do not call only succeeded when there was a regulatory basis to enforce the opt-out decision. And up till that point, it had virtually no pickup. And once people understood that if they took this simple act, they would deal with the problem of telemarketing calls at home during dinner, it became extraordinarily popular. And this, I'm afraid, is what's not going to happen with Do Not Track. Because we're going to have a lot of good discussion about a lot of innovative technology that would help solve the problem. But without this, and this is, again, it has to do with the rationality of actors. It's not that I'm against markets. Where markets reflect choice, fine. But people will not make the choice to exercise Do Not Track unless it turns out to be enforceable and meaningful.
But Mark, we're not disagreeing for once.
Yeah,
I mean,
that's the point.
But
The question is, what's the consequence of what you just said?
exactly. And our basic point is that in your world, the opt-out rates would be high, as you predict, because of that essentially do not call. But this is fundamentally different, because in do not call, the telemarketers weren't paying for your dinner. Right? So there really wasn't a trade-off involved, and here there is. And the basic point, to put it bluntly, is a no-cost opt-out is not scalable.
Well, so I
But
don't want to cut this. I wish we could talk about it all.
really no cost? Because you pay for your privacy on the phone. You can pay to have your number not listed.
No, all I mean to say is that there is a real trade-off, as this gentleman over here was getting at, in terms of the data that's collected online. And this gets back to the conversation we're having this morning about content ID and marketplaces, and to think somehow that we can just build a magical marketplace where where the opt-out becomes costly. That is, if you want to opt out, the website responds and says, okay, we'll interact with you and we'll charge you or something. That works in a world with no transactions costs.
Can I just add,
But it
I
doesn't
know
work so
we're
well.
late, but this is such a fascinating issue.
You know, I defer to you guys.
The consequence of enforcing Do Not Track, which would be to reduce the profiling of internet users, I believe would actually lead to more support for internet publishers. In other words, this view that says that if we don't have people being profiled and tracked based on their individual preferences, the free internet goes away, is actually backward, because when you reduce the burdens on privacy, you create incentives elsewhere, and I think that will lead to more online publication. But that could be the topic of a future.
Last word, yeah, I mean, it could be an entire day on this, but last word from Marc, and then we'll move on.
Thanks, Ryan. I actually don't want to talk about Do Not Track, even though I've been very involved in it, but since the libertarian contingent is out in full force today, I wanted to a little bit of a counterpoint to the question of whether or not there's been a market failure in this area. And Jim's point all along has been that consumers are in fact choosing what's rational. They just have different preferences than you. They choose convenience over privacy or something else over privacy, etc. I think that is a valid point, but I think that that something else you said is also a mischaracterization of what Marc brought up, for example, about Alessandro Chisti's work and other excellent work in behavioral economics, which is frankly a little bit depressing to read, but I think it's, it makes a great point that consumers are not rational from any such perspective that you can imagine. And let me give you one example of that. There are dozens of these examples, and one of them is something called framing, which I'm sure many of us have heard about. Consumers make very different choices on the exact same question depending on how you frame it. whether you want to pay $2 extra to gain privacy, or you can get $2 extra by if you agree to lose your privacy. It's the exact same question with very different answers. And I want to point to this paper called "What Can Behavioral Economics Teach Us About Privacy?" by Alessandro Chisti. There are a ton of these different categories where consumers make self-contradictory choices, and when it's self-contradictory, it's hard to argue that it's rational from some other perspective.
I'll offer a paper. Italy has featured so prominently in our discussion today.
It's true, yeah.
Alessandro Chisti is a great, interesting guy. The Istituto Bruno Leoni, which is an Italian free market institute, put out a great paper called "Are Regulators Rational?" Regulators and folks who believe in regulation have many of the same biases and mental errors that we argue consumers have when we say the regulator should take over, including action bias. We should do something. Jump to the left when the guy shoots the ball. Well, statistically, goalies should stand in the middle of the goal, but they jump to the left. Regulators statistically regulate rather than let things well enough alone. And it's not necessarily so that we're better off. Regulators have the same problems that consumers do.
All right, that is the last part. Thank you to the panelists.